This video will detail the information that needs to be provided to the assessor's office following the death of a property owner. It will also discuss the various assessor forms that are required to provide that information. Funeral directors and their staff play an important role in assisting families in times of grief. This can include navigating the various reporting requirements of the assessor. Let's now begin by discussing some important assessment concepts and information. Anytime a property owner dies, the county assessor must be notified so it can maintain accurate records. Notification can be done by filing the form Change in Ownership Statement, Death of Real Property Owner. This form must be filed within 150 days of the date of death. If the estate is probated, then it must be filed at the time the inventory and appraisal is filed. The Change in Ownership Statement, Death of Real Property Owner form is required to be completed and submitted to the assessor's office. This is true even if the decedent held the property in a trust. Keep in mind, failure to file a change in ownership statement within the time prescribed by law may result in a penalty. Shown here are the most common will scenarios following the death of a property owner. 1. If the decedent had a will. 2. If the decedent did not have a will. And 3. If the decedent had a trust. Also shown along with the required change of ownership form discussed previously are the supporting documents that need to be filed in each case. Optional documents that may be submitted are the following exclusion claim forms. Claim for reassessment, exclusion for transfer between parent and child, Form BOE 19P, and claim for reassessment exclusion for transfer from grandparent to grandchild, Form BOE 19G. Property tax savings are available for children inheriting property from their parents. The parent-child and grandparent-grandchild. Transfer exclusion, Proposition 19, allows for the transfer of property, along with its base year value, to a person's children or grandchildren, as long as the following conditions are met. First, the property must be the principal residence of the parents or grandparents. Second, the property must become the principal residence of the child or children, or grandchild/grandchildren, within 1 year of the transfer. Applicants must also file a homeowner's exemption claim within 1 year of the transfer for this benefit to apply. Third, a parent-child transfer exclusion or grandparent-to-grandchild transfer exclusion claim form must be filed within 3 years of the transfer or before the property is transferred to a third party, whichever is earlier, for the full benefit to apply. Can the property be reassessed upon the death of the owner? Yes. According to state law, a transfer on death is considered a change in ownership, and the real property or the manufactured home that is subject to local property taxation can be reassessed as of the date of death for property tax purposes. Can the property be reassessed if the decedent held the property in a trust? Yes. A property owner that holds their property in a trust is referred to as a truster and/or present beneficiary. Property held in trust may undergo a change in ownership and be reassessed when the truster and/or present beneficiary of the trust passes away, unless an applicable exclusion applies. The change in ownership and, if applicable, the date of reassessment is the date of death of the property-owning truster and/or present beneficiary, not the date of distribution to a successor beneficiary. Do I still have to file a change in ownership statement? If the property was held in the decedent's trust? Yes. Whenever there is any change in ownership of real property or of a manufactured home that is subject to local property taxation, the transferee shall file a signed change in ownership statement with the county assessor in the county where the real property or manufactured home is located. For transfers that occur upon the death of the property owner, a change in ownership statement must be filed with the assessor's office within 150 days of the date of death. However, if the property is subject to probate proceedings, The change in ownership statement shall be filed prior to or at the time the inventory and appraisal are filed with the court clerk. What happens if a change in ownership statement is not filed within the time frame prescribed by law? Failure to file a change in ownership within the time prescribed by law may result in a penalty. Additionally, when the change in ownership is discovered, the assessor will determine if reassessment of the real property or of the manufactured home is required under state law. If required, an appraisal is made to determine the market value of the property as of the date of death of the property owner. The resulting market value of the property will be enrolled as of the date of death of the property owner. The assessed value will be corrected for each year thereafter pursuant to Proposition 13, and adjusted tax bills will be issued. How does the assessor update the mailing address in a death of property owner situation? The mailing address will remain the same until the assessor is notified via a new deed or upon receipt of documentation naming the decedent's administrator, executor, or trustee, along with a completed assessor's change of mailing address card form, Assessor 451. To avoid problems, update the mailing address with the assessor as soon as possible. Are parent-to-child transfers automatically excluded from reassessment? No, in order to receive an exclusion, the claim for reassessment exclusion for transfer between parent and child must be filed with our office. To obtain a retroactive exclusion, a claim must be filed within 3 years of the transfer or before the property is transferred to a third party, whichever occurs first, or within 6 months of the mailing date of the notice of escape or supplemental assessment issued in connection with the transfer. If the aforementioned filing requirement is not met, a prospective exclusion, commencing the year a claim is filed, may still be available if the property has not been transferred to a third party. If you have any additional questions or concerns that were not addressed in this video, or need additional guidance, please reach out to the Assessor's Ownership Division. Contact email and phone numbers are shown here. Our website also has many additional self-serve resources, including fact sheets, forms, and FAQs, available to the public 24/7. This concludes our video on death of a property owner. The Los Angeles County Assessor's Office and our assessor, Jeff Prang, appreciate you taking the time to watch this video.